Hello again, everybody. Ben Joravsky here. We're calling Let's Go to Law School Tuesday, and here's why. The great Jim Coogan standing by. We're going to law school, ladies and gentlemen. Yeah, take out your pencils, take out your paper, take notes, all right? We're going to law school. A lot of legal issues. I cram my brain. I was telling Jim before the show, I crammed all this stuff into my head. It's got about an hour. I got an hour, Jim, before it just expires. So many things. I woke up this morning at the early hour of 10 and saw that the Supremes had issued a decision in a First Amendment case out of Colorado, which I was just had me smiling because Jim's heard me on this subject so many times. He could probably do the show, my part of the show, for me. And that is they tailor whatever principles they have to fit whatever political end they want. So in this particular case, it was a First Amendment issue, and I'm very, 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 very susceptible to the First Amendment arguments. In fact, we're going to start off with First Amendment arguments. Get ready, Jim. You don't know what curveball I'm throwing at you. And so the First Amendment argument has to do with a case regarding, doctors, what doctors can say to their patients. And so there was a law passed in Colorado banning doctors from advising that their patients go for therapy, conversion therapy. So if you're gay, you go to a therapist, and the therapist brainwashes you into thinking you're not gay. To me, it sounds like just a total canard, a joke. But did they go too far to ban it? If a doctor wants to promote a canard, phony medicine, doesn't that doctor have a First Amendment protected right to do so? If the doctor says, "Oh, if you if your heart is ailing you, let me take out your gallbladder," does the doctor have a First Amendment protected right to do so? And according to the Supremes, and I think it was 8-1, so even some of the liberals went along. Yes, they do have a First Amendment protected right to say, "Hey, if your heart hurts, you can get your gallbladder out." Okay, let's go. Your heart hurts. Let's amputate your toe. All right, that's the Supreme. Now, I personally believe it's because they have most of the Supremes have an aversion in any way to anybody who is not "quote unquote" straight. And that's what it's all about. That's me personally. Jim's free to disagree with me. We're a First Amendment protected podcast. So I allow disagreements from my guests, which happens all the time. Now, the part that triggers me is this. We also have states throughout the country, red states, prohibit doctors from giving whatever advice they want regarding abortion care. So doctors have to read a freaking script, essentially, when it comes to abortions. Well, you should think about this for 24 hours, or there's alternatives to abortion, or did you know that some study by somebody said that abortion can be hazardous to your health? All these things a doctor has to do, scripts that the doctor literally has to read. And so I say, Neil Gorsuch, what about that doctor's First Amendment protected right not to have to read this script? Anytime, Neil, anytime you want to rule that an abortion doctor has a First Amendment protection right, the same First Amendment protected right that the anti-gay person has in Colorado, I will applaud you for consistency. But until then, it's not consistent. There's no philosophy here. There's no rooted principle. It's just politics. You got power, and you're going to use it. And you're going to use it to slap around the people you dislike. And in case of Neil Gorsuch, like Kavanaugh and Alito and Thomas, they have made it clear in their lifetimes that they cannot stand liberals. And so I'm suspect of any decision that they reach. And Jim has heard me on this topic for 8 years, my friend. I don't know if I've convinced him. I feel like I've pushed him in this direction. But so I got the First Amendment on my mind right now. And we're going to law school. We're going to talk of First Amendment and meta and personal injury lawyers. Love personal injury lawyers. And we're also going to talk sort of a First Amendment case, more like a property rights case. I'm really dying to hear Jim on this subject because it combines sports and law. Can Caleb Williams, does he have a legal right to trademark a nickname, in this case, the Iceman? I've said definitively no. But let's see if Jim agrees with you on that one. I can't wait to have that conversation. And then DOJ pays $1.25 million to Michael Flynn. This is something that Jim sent me about 3 weeks ago, and it just blew my mind. I had missed it when it first came out. Oh my God, what a racket Trump is running. God damn. So anyway, I'm going to bring on Jim right now, and we'll take it away. Welcome back, Jim.
Ben, it's good to be back.
So feel free to vigorously disagree with my oration that began the show regarding the recent decision, First Amendment right decision coming out of Colorado. Go ahead.
Well, here's the framework that they used.
Go ahead.
They called this viewpoint regulation, meaning that it's speech, and because it is of a particular viewpoint, essentially they're once you frame it that way, then it must surpass what they would call strict scrutiny, meaning that the law itself, what it's designed to do and accomplish, and how it does it has to be very isn't even enough of a strong word. It has to be so strictly, carefully tailored as to essentially, there's really no way to thread that needle. There are very, very, very few ways and times that this kind of regulation of speech has been permitted under the First Amendment. But essentially, once the court determines that that is what's happening, then you move on to, well, can whatever the regulation from whatever state has passed that law, can it survive that scrutiny? And the answer is almost certainly no. It's almost never possible. So then if you were of the mind to criticize this decision and you were trying to figure out ways that you might find fault with it, it's not really going to be on the application of strict scrutiny. Rather, it's going to be whether this is really viewpoint regulation in the first place. The way, like, this is, without having read the entire decision, the notion that a doctor can frame what they're doing here, this kind of therapy, if they want to call it that, as speech, I think has some problems to it. Your analogy to regulations regarding abortion care is apt. And there are many regulations that require at least a delay of an abortion before a variety of things happen first. And that's been one of the ways that Republican, right-leaning, anti-abortion politicians have attempted to frame these issues in the past by creating small, little, increasingly complicated barriers, complications, hurdles that someone would have to overcome. For example, where they would require that a parent be notified or a husband be notified, to shame the person, really. And all of a sudden it takes the decision making out of their hands, treating a woman who's now pregnant and supposed to not just carry this child to term, but also raise that child as a child themselves, that they're not capable of making their own decisions. So I think that's a very apt analogy. And there are a variety of those regulations that are legal. They exist. States enforce them. Doctors have to abide by them. As you pointed out, there was only one dissent, and apparently Justice Jackson read a summary of her dissent from the bench, which is intended to carry some significance in the Supreme Court world. There's all kinds of traditions, and it's a very narrow, small little universe of people who are super tight Supreme Court watchers, and they understand these things. There's ways that people behave. There's collegial relationships between the justices, and little things like a justice standing up and reading a dissent from in front of the court is intended to signify just how strongly they dissent. And probably here, especially when she's the lone voice saying that this isn't a proper application of strict scrutiny, and therefore it shouldn't have been illegal for Colorado to restrict this kind of therapy. She's trying to emphasize that this is something that's dangerous. I mean, the whole point of this regulation, God forbid we talk about the thing itself and what it is intended to do, essentially says to the person who is allowed to do this kind of therapy, you get to control someone's sexuality, and basically shame them into thinking that it was inappropriate for them to be gay in the first place, to be a homosexual in the first place. And there is well documented evidence of how dangerous this therapy could be. People who then engage in self-harm or commit suicide because they have been told that they're actually wrong, that this is a flaw within them. Well, when you start going down that road and it's a medical person telling you that, suddenly you think you're the problem. It's not that you've had these feelings all your life, and yet those feelings are actually wrong. And the medical community thinks that they're wrong. So the whole purpose of states, including Illinois, banning this kind of therapy was that it was ineffective, it didn't work, that it's inappropriate, that it doesn't actually treat a medical condition, and that it's dangerous. And that was the whole point of this in the first place. So as Justice Jackson, one of the quotes here was, and I would read this from her, the Constitution does not pose a barrier to reasonable regulation of harmful medical treatments just because substandard care comes via speech instead of scalpel. It's a well-written phrase because her point is she's essentially saying you're missing the point.
Yes.
This isn't about speech. It's about medical regulation. And I would have to read the concurrences or in what way the rest of the justices joined with this majority to understand why they went along with this framing. Unfortunately, I didn't have a chance to do that yet, but I plan to, because it's a curious thing that they would concede that this is indeed speech. And just like abortion care, there are parts of medicine that might at least touch against the border between straight up medical care, doing something that's a scientific thing, and where your beliefs lie. But I mean, there's no, for example, if you're a Christian Scientist, you don't believe in transfusions, they're not saying that doctors can't perform, like nobody's out there saying doctors can't perform transfusions just because the person who would be receiving it doesn't want it. I mean, that's their choice. In other words, it's really the restriction on the individual person, the patient, versus the person performing the medicine. And frankly, I don't know, and I would have to educate myself a little bit better. I don't know how this is even legitimate medicine in the first place. This conversion therapy, as they call it, because to my mind, I'm not an expert on it, but I've read things about it being heavily discredited over the years for the reasons that we've already identified.
Well, to that last point you made about a Christian Scientist, flip it. Think about if the doctor were a Christian Scientist. Does that doctor have a First Amendment-protected right of freedom of speech and freedom of religion right, which freedom of religion has been really promoted by the current Supremes, not to advise a patient about the health benefits of transfusion? If that doctor I cannot in good conscience, because of my religious convictions, even tell a person about this, then that's harmful. But the Supremes right now are saying that doctor would have, if you apply the principle, and this is where I say they have no principles, Jim. They're just tailoring these decisions to fit whatever prejudices and biases they have, that as far as I could tell. That's why I find it so maddening. The same Trump administration that trumpets pun First Amendment free speech protected rhetoric is the one that's firing teachers, or their allies in states like Florida and Texas are firing teachers for what they teach, if they affirmative action or DEI or Jim Crow curriculum. And so I don't see a consistency. And so this kind of gets into the area that you talk about a lot on this show. If there's no, if there's no underlying principle that's being, that's rooted in these decisions, then they're effectively tools of totalitarianism, where they just tailor whatever decision they make at that moment to support whatever the king wants to do. and I find it frightening. Your thoughts?
Well, okay, so the real danger in what you're identifying there, and just a quick digression, I was trying to figure out the right way to have an analogy about a doctor who didn't want to transfuse somebody, because I don't know how the state would obviously, no state, rational state would say, we're actually going to restrict you from doing this and you should be able not to do it because of your speech beliefs. But anyway, the real danger, and so if you took originalists at their word, then part of the purpose of originalism would be to undergird the legitimacy of the decisions that the court issues in the first place. So it's not just that we're appealing to words should mean what they say, plain meaning of the words. That theme, that philosophy is supposed to be self-supporting, because every court of review, especially a Supreme Court, where you're not just looking at mistakes at the lower level, you're actually setting policy to some degree. You have to protect your own legitimacy. That is a critical piece of every Supreme Court, every constitutional court throughout the world, for every system of government that has one. And protecting their own legitimacy has been a fight. If you study the early days of the United States Supreme Court, that was an issue. Where did you draw the line? Where did their power exist? And part of the way that they could maintain and declare their own legitimacy was with consistency, following their own precedent, making sure that they're not writing decisions that just seem to be made up whole cloth, that they are based in the actual terms and language of the Constitution. So originalism is, at least it espouses to be based on supporting its own legitimacy. But if in practice, the way that it is actually effectuated and the way that the decisions are written don't look that way, then it doesn't matter how much you dress up your opinions with what you claim to be originalism. You can say words about precedent. You can say words about why you're following it. You can even include dictionary definitions and pretend like you care about what the words mean. But eventually people see through it. You know, you can show up at conferences and write books and try to create like a superstructure around the court that pretends like you're really engaged in originalism or that what you're doing is legitimate. But the more that the decisions essentially seem to follow your political preferences, the more like that you're already exposing the legitimacy of that court to criticism, and you're undermining what you claim to care about. So the irony is, originalists do seem to understand how significant precedent is, and that plain meaning of words, following legal concepts that are well established, that feel like the product of years of hard won and hard fought experience. They seem to understand that that's significant, but they also just seem to use it as a tool, as an artifice, as a veneer to paint over the outside of what is otherwise just a politically motivated opinion. We've seen that multiple times. And the most egregious example, of course, is always the Dobbs decision. I will, as a little aside, if you'll permit me, I was hanging out with some people on the way down to the Chicago No Kings rally on Saturday. And there were most of them were teachers. A friend of mine is a teacher. And somebody, of course, someone had to out me as the non-teacher in the group. And we got to constitutional issues at some point. And I was, I kind of got on this diatribe a little bit about originalism, what it really means, Antonin Scalia, kind of explaining it. And I can't remember what led us down that path, but it's a theme that I think informed voters are picking up on, because these decisions have so violently betrayed what is otherwise supposed to be stare decisis and precedent. And stare decisis and precedent, they're just fancy words for something that you can just feel in your gut. Yeah. If something is decided and the rest of society sort of builds itself around that thing, even if some people aren't happy with it, eventually it feels like it's the law. It's like something that's got more gravity than just you can write some new words on a page, or just use an eraser, or just line out the parts that you don't like. It's got real gravity to it. But they're erasing those things as well. Or in this case, it seems like they're unnecessarily and possibly irrationally expanding what constitutes speech in the context of medical care in order to invalidate a regulation that's probably safer for people. I mean, I'm sure there's ideologues who think, well, just being gay is more dangerous than whatever could happen to you if you go through conversion therapy. But I don't think that that's true personally, and I don't think that if you did a study on this that would be borne out.
Yeah. Well, to the point you just made, again, if you're not willing to expand free speech principles to doctors who provide abortions, that you can't turn around and claim it as a right that a therapist has. It's one or the other. You either believe in free speech for doctors or you don't believe in free speech for doctors, or you're using it selectively. And that's the part that I keep hammering at. The selective enforcement of principles when they fit one particular need and then they get abandoned. So to the point you made, we talked about this. I don't know if you remember the conversation we had in the last election cycle in 2024, I think it was. I can't remember when the actual ruling came down. The Supremes ruled on behalf of Donald Trump against the state of Colorado, once again, Colorado, and claiming that Colorado did not have the right, even though it's enshrined in the Constitution, to regulate the ballot. And in Colorado, there was a movement. A judge, I think, ordered Trump off the ballot, didn't he, for being an insurrectionist? Didn't
The appellate court upheld that decision. Yes.
Wow. And then the Supremes overruled it.
That's right.
And I believe it was unanimous. They got the liberals to go along with it too. And so I'm like, okay. So Dobbs proclaims that states have the right to regulate abortion. And then 1 year later, the same group of guys go, oh, but states don't have the right to regulate ballot access. So that's why I'm saying, Jim, try teaching that to 16-year-olds in a civics class.
And then have them look at the plain language of the 14th Amendment, which is what the Colorado ballot decision was based on. And it didn't seem like a stretch. And including a massive fact-finding hearing that went through all the reasons why that constituted a betrayal that was akin to the kind of treason that occurred during the Civil War, and therefore the person shouldn't be allowed to be on the ballot, which was the whole point of the language being in the 14th Amendment in the first place.
Yeah, and then I remember their argument, well, if we let Colorado do it, then every state's going to do it, and they're going to do it to Biden. Well, my attitude is, well, if you got that stronger case against Biden, let's see it.
If he's committed that kind of egregious conduct against this country, then he shouldn't be president either.
And by the way, anyway, it didn't matter because with our crazy electoral college system, you don't need to be on every state. You don't need to be on the ballot of every state. You just got to be on the ballots of swing states and your home states. So,
right. And so if you think it's an irrational, arcane, preposterous system now, wait for that potential reality where candidates are on 27 states, the other one's on 33. I mean, we haven't gotten to that point yet, but they're trying to break the system at every opportunity.
All right, so let's sort of stay on the same topic, but switch gears a little bit. This has to do with a jury's decision. I think it was last week in a case regarding, well, I always call it Facebook, but it's actually Meta. I think Google was a defendant as well. Correct me if I'm wrong, Jim.
Yes, because of YouTube.
Because of YouTube. I thought the YouTube case on this part was kind of weak as opposed to Meta, but we'll get into all that. The jury decided with a young, she's not identified. I think she was like 16-year-old. Her parents are obviously behind the lawsuit as well, who says she was suffered harm. She got addicted to either Instagram or Facebook. I can't remember which one. And then her lawyers, personal injury lawyers, took apart the device itself to show that it's set up to create addictions, and they therefore can be harmful. It was very similar. I saw by chance, Jim, just this weekend. I don't know if you ever saw this movie. I'm always telling you about these movies from the 90s. The Insider with Russell Crowe and Al Pacino. If you ever saw that movie about Russell Crowe plays the insider who whistle blows on the tobacco companies, and it gets in the issue of how cigarettes are manufactured to build an addiction. The the way it's set up to get you addicted to it. And similarly, the Facebook and Instagram are set up to get an addiction, and the jury decided with it. And again, I think the verdict was 6.5 million, something like that. And immediately there was a reaction across the board that there's a violation of Meta's First Amendment rights. So before we go down there, what's your thoughts about that case and the role that your profession, personal injury lawyers, played in it?
Well, okay, so the most significant takeaway, and it's a seismic takeaway for the entire tech industry right now, because so much of big tech is tied in with how do you get people to keep watching your whatever, whether it's, Meta is dedicated almost entirely to social media, whereas Google, Alphabet has other things, but there's still an engagement factor that all these companies are worth what they're worth because they have our attention and because we depend upon them for a variety of both communication things and searching and finding information and planning our lives. So in the past, when companies had been sued for really, I guess the suits would be ineffective and regulation would be ineffective because of Section 230 of the Communications Decency Act, which is like this funny anachronism that was a law that was passed, I think, in 1996, way before anybody knew how any of this stuff was going to work. And yet it continues to rear its head, and it's become a political football. Republicans have been against it and for it, and Democrats have been against it and for it, for repealing it, for changing it. And it ends up being a very convoluted political argument, because essentially what it says is the platforms themselves are not responsible for the content on the platforms. I'm oversimplifying, but that's enough. So the point is, if something exists on Instagram and it's hooked you in, and it's the content that's hooking you in, well, you can't sue Meta for that addiction, even if you could prove you have it and you could show the damages and how it's affected you needing therapy, or suicidal ideations, or even suicide attempts, or whatever the poisonous mental health consequences that you've had. The wrinkle here is that the attorneys found a way to work around that and avoid what would otherwise be a way to defeat the case just on the law, where a judge dismisses it entirely, would be based on Section 230. Instead, they focused on the design of the product. So if people have heard of product liability cases, yes, that included what happened with Philip Morris and the tobacco companies. It included the extremely, it's becoming less well known now, but the thing that led to Ralph Nader becoming an international figure was looking at the product design of a vehicle that essentially exposed the people driving it to instantaneous death, and that they were more or less doing a calculation that paying off lawsuit settlements was cheaper than redesigning and reconfiguring the product and doing it in a safer way that wouldn't lead to the gas tank exploding on impact. So product liability is a very viable, serious legal theory of recovery under the tort system. So personal injury lawyers, including myself, can file lawsuits if we can figure out that either the design of this thing was done in a way that was unsafe and that there were alternatives that could have been done instead, or that particular product was just manufactured improperly. That doesn't apply to this case. Here, they're essentially saying, and they went to go prove it, and they brought, Zuckerberg was at this trial. They had the people who are in charge of these companies, very famous, internationally famous figureheads, were testifying at this thing, because the plaintiff's case was premised on the idea that not just that it was dangerous, but what they showed the jury was that the internal memoranda and meetings and communications among executives, they knew that these things were happening. And they would, for example, they would suggest, well, don't use words like addiction when we're writing these memos. Like there were smoking gun documents like that showed consciousness of guilt, not just that they had an understanding that these things were dangerous, but that they were trying to hide that because they must have assumed that one of these days a regulator or a trial lawyer is going to get a hold of this memo and they're going to use it against us. Well, that's what happened. And I will say one other observation. I'm sure you have more questions, but just to point this out, one thing that I am very used to whether it's a car crash case for a client who gets rear-ended and has spinal injuries and they used to have some back pain before, or it's a medical malpractice case where so many of our medical malpractice clients, they have medical issues. It's the reason why they were seeing those doctors or went to that hospital in the first place. Not most, very, very often, one of the defenses in these cases is to point the finger back at the person making the claim. They're taking advantage of all kinds of biases that have been baked into our culture for the last 50 years, where anybody who files a lawsuit, well, you should be a little skeptical. Who knows if that guy's on the level? Maybe he's exaggerating his pain. Maybe this thing didn't happen the way that he claims that it did. And certainly, you're the litigant. You're bringing the case. You do have the burden of proof. But they often try to blame the victim. And I don't like the term victim, but blame the person who's bringing the case and point out whatever foibles they might have, or something that's completely extraneous, is not even related to the case, and make it all about that instead of about this crash. And this crash led to going to the hospital, and then they had an MRI and it showed spinal damage, and then they had surgery. Like, that's a very straightforward story, but they want you to look over here at the shiny object. In this case, the defense lawyers for Meta spent a lot of time demonizing, vilifying, and essentially blaming this young woman who's now in her 20s. I think KGM were the initials that they used at this trial, that she had other communications where she would talk about her mom being insane, or, complaining about life at home, or being depressed, or being upset, which, not for nothing, if you look through the text messages of a 16-year-old to their friends, I'm sure you're going to find, every parent in America would probably be subject to those same criticisms, right? So I assume that part of the reason the jury found in favor of the plaintiffs is that they understood these things. That's common sense. That's just, look, kids are going to take shots at their parents. It doesn't mean that she was abused. And it also doesn't mean that even if her home life was part of the reason that she had mental health issues, that it wasn't also contributed to and made worse by her addiction to using Instagram. And that's the point. Especially if we're talking about teenagers. That's the whole point of, the other verdict that happened that same week was in New Mexico.
Yes.
That was for $370 million, including punitive damages, based upon their characterization of this law. And the whole idea is that a minor, and we have seen some changes, some of these companies have adapted their policies for minors over the years, but they've also gone back on some of those restrictions, and they've loosened those restrictions. And I think that was an issue at this trial. If you're talking about a 14, 15, 16-year-old child, they're going through a lot of things. Puberty is arduous. The hormones are raging. There's all these changes. It's a very unhealthy, challenging part of everybody's life. Like, everybody looks back at their teenage years, and for all the exciting, crazy stuff they might have done, there's all these sad, difficult, challenging arguments, whatever. So if you pile on top of that a thing that's going to make you feel isolated, a thing that's going to make you feel like, well, everybody else is living a cooler life than I am, a thing that makes you feel like, well, gosh, I wish I had that money. I don't. My parents aren't rich like that guy's are. It's only going to make it worse.
Yeah.
And so one of the other things that I've seen commentary, which is sort of fascinating, and I have absolutely zero sympathy for them, is the notion that jurors sitting on cases, because there will continue to be more of these cases, have a negative view of these platforms and think that they are deleterious to society in the first place. This is the bed that you made, guys. And the guys at the top of it have made so much money, it's hard to believe that they really care. So that's the end of that.
Yeah, no, and
especially when they let their lawyers go demonize the woman who, was the plaintiff in this case in the first place.
Yeah, well, as you know, because you've been in the game for a while, that's 101 of how defense lawyers handle these matters. They in fact, they essentially, I base this on 1,000 movies I've seen, but there's that moment, Jim, where the trial attorney has to prepare his or her client, and they go, they're going to rip you to shreds. Every secret. I just saw this in the Russell Crowe movie. Every secret you ever had is going to be exposed. Tell me everything I should know so I can deal with it when it comes on the stand. And so, that's a tactic. That is a standard tactic. All right, so I'm going to get your thoughts on one of the counter arguments that I was just exposed to. I read it today. I didn't have a chance to send you the article, but I can do a pretty good job of distilling it. It's by a columnist for the New York Times named David French. And it has to do, the headline is "Don't Cheer Too Hard for the Facebook Verdicts. We Should Wean Americans Off Their Phones, but not at the expense of free speech." Now, I have to say this about David French. In my opinion, he's the exact opposite of Neil Gorsuch. And by that, I mean he's a man of principle. I disagree with him on a lot of issues, but I fundamentally believe that he's standing by his principles, and he doesn't dilute them or change them. That's my based on reading his columns down through the years. He's one of those few conservative writers that I read with great interest to see. Okay, what's his argument and how compelling is it? In this case, he's acting as an advocate of free speech. And he's essentially saying that this jury, as much as he disdains the cell phone culture, as much as he wants to wean his own teenage children of their love for the cell phone, and as much as he realizes what a danger it is, he believes that that verdict is taking us to an extreme where we are impacting free speech. And he says effectively that the algorithm in a phone, and I'm just going to repeat his argument, Jim. This does not in any way mean I endorse it. The algorithm in the phone is the equivalent of a newspaper layout. And so this is an argument that Justice Kagan made in another case, which I don't believe in any way, I have to tell you. In any way do I agree with this position. And so he has an aversion to that verdict, and he thinks it's going to be damaging to free speech rights. Your thoughts to that argument? Go ahead.
Yeah, I could hear it as you're saying it. I'm also trying to scroll through it. I get it that the algorithm could be analogized to like the editorial construction of what goes into a paper and what's being reported on in the first place. I think that's an apt analogy. I don't know if that's actually how these things function, even if it's analogous. I mean, we're talking about one era of technology that's completely analog based, even though now everybody except for Ben Joravsky gets their news on a screen as opposed to delivered to their house in a piece of paper. But sorry, that just kind of that wrote itself, Ben.
Yeah.
But the jump in technology, the sophistication of it, and the way an algorithm works is substantially different in ways that I think are meaningful for what argument he may be making there, which includes in part that newspapers, when it was an editor, an editor of like the Chicago Tribune would be deciding what they think is newsworthy based on some objective standards, and they might check with their editorial board, or they might decide to start putting certain articles about restaurants on the front page or in the early sections because there were issues locally about food safety or restaurant workers being abused or something like that. So they reconfigure an algorithm in these very, very sophisticated systems is hyper tailored to that user in ways that newspapers could never have been, and even now still aren't. I mean, granted, they're on an app or a web browser, I'm sure they filter things to me differently than they would to you, but it's not tailored the same way that Instagram would be. There was another passage in here that I really found interesting. Oh, talk about a depressing observation. Like he says, I'm also a concerned citizen who read Jonathan Haidt's transformative book, The Anxious Generation, and watched with alarm as prior generations, sex, drugs, and rock and roll were replaced by anxiety, depression, and suicidal ideation. What a sad, I mean, granted, that's what parents in the 60s were worried about, that their kids were exposed to, was like counterculture. But those are at least, certainly they could be taken to extremes, but they're at least liberating things. They're an expression of you becoming an adult, going on your own, experimenting sexually, or experimenting with drugs, or just listening to music that changes your worldview. I mean, that is what this generation of teenagers is really kind of laden with right now.
Yeah, no, I have to agree with you. Like, if you just read the first part of David French's essay, it's so convincing of the evils of social media and how they get kids addicted to things. And then he does the flip, but speech is important. And I'm like, David, just as one writer or another, you were far more compelling with the part of the argument that you were not actually advancing.
Yeah, I don't know that that I'm too concerned about the free speech of algorithms in this context. And I mean, he says he read it. He says, I'm also offended by, learning about the internal documents that reveal how much they knew about their own product.
Yes.
So to the extent that this, if it damages Meta's market value so much that the company has to disband or change themselves or it just goes out of business, I'm not going to cry any rivers. I mean, even the workers at those places are very talented. They'll work for some other tech company because it's not as if this doesn't spell the end of big tech. That's virtually an impossibility in the world that we continue to create.
Yeah.
So, and if this changes how many libraries or whatever that Zuckerberg can name after himself, I'm not really worried about that either.
Yeah.
Like, it doesn't, at some point, whatever the titular head of these places are, who cares? There's going to be another one. There's going to be some other guy who wants to replace Elon Musk or Mark Zuckerberg as the scion of whatever this technology is.
So I'm thinking, based on everything you said and what David French wrote, and I'm trying to figure out what the long-term impact of that jury's decision is. So it'll be appealed. My guess is they may be successfully appealed and the actual verdict at 6.5 million is reduced. So right now, the only cost Meta has so far has been their defense lawyers. They haven't paid a nickel to the plaintiff. The plaintiff's lawyer is doing this on a contingency, I presume. And so it is a he, hasn't been paid a nickel. He's put up the money to do this. Do you follow what I'm saying? Meta is so rich, they could do 1,000 of these cases. They could do 10,000 of these cases, Jim. They could just run out the clock on these cases. I don't see this as the equivalent of what was the issue that it was raised in The Insider, the movie The Insider, where cigarette companies had eventually come face to face with the consequences of having an intentionally addictive product that they put on the marketplace and had to pay large amounts of money. Or in the case of the NFL, it's a similar thing where the NFL had to put aside large amounts of money to deal with the concussions that so many players had over the years. I don't see it here. I actually don't think it's as significant an impact as French and others are making. Your thoughts?
Well, first of all, Meta's stock was up 6.2% today because there was a big relief rally over whether things will cool down in Iran. But their market capitalization is $1.36 trillion.
Damn. God damn.
So, and relative terms, you have to take into account inflation and the size of GDP or something like that. But I don't think that Philip Morris was ever worth whatever 1992's version of 1.36 trillion is. I mean, maybe. I don't know for sure, but I doubt it.
Yeah.
And what they were building and what they were selling and what their company was based on was a tangible thing that you had to literally smoke in your hand.
Yes.
So there was always a limit to how much of that you could sell to anybody.
Mm-hmm.
Here, the product is the product is really the people who are using it, but there's really no limit to it. I mean, in some countries they use Facebook as like their quote unquote internet.
Mm-hmm.
So it's yes, I don't think this is in any way exposing them to being eliminated as a market venture. But like I said before, I don't think it matters because there's also a huge difference between reinventing into some other company or fragmenting off versus what do you do with all the kilns and all the manufacturing plants that used to roll the cigarettes and put the filters in? Like reconstituting this into something else would be, I'm sure it's not as easy as I think it is because I don't really understand this stuff technologically, but it's not the same issue. And it's not a bunch of workers like in fields in North Carolina that are being put out of work if it happens either. It's a very different proposition.
So the lawyer who filed this case uh, is an extremely successful personal injury lawyer. I believe he's from Texas. Correct me if I'm wrong. His name is Lanier.
We're
And
not actually trying to advertise for other personal
I'm
injury
sorry.
lawyers on the show here, Ben.
He's
No, Mark
mostly,
Lanier is a terrific lawyer. He's
yeah,
very,
he's
very
one of the
successful.
best.
He's
Yeah.
tried some very complicated, big cases, including like cancer cases where people, talcum powder caused ovarian cancer and some other big ones. Yeah.
Big time, very successful lawyer. Modern day Jerry Spence. Jim knows I got this thing about personal injury lawyers. I follow them like some kids follow baseball players. That said, I'm like, why take this case? He's not going to get paid. I don't know if he'll ever get paid for this case. Would you take this case, Jim?
Well, I think what'll happen is they will appeal it, and I don't know enough about whatever legal issues were raised. I mean, like, for example, we talked about the Communications Decency Act. They probably filed a motion for summary judgment on that basis somewhere along the way, and a bunch of other free speech bases. And those you can infer that they were denied because the case proceeded to trial. So they can re-raise all those arguments on appeal and maybe make one stick. But whether they do or not, this is just a bellwether, because there's 1,000 other claimants or 5,000 other claimants or whatever. I don't know how many the Lanier firm has. Several other big mass tort type firms would have lots of other hundreds, if not thousands. I don't know, maybe 10,000 claimants. So it becomes a marker to increase the settlement value of those cases. And keep in mind, there is always a give and take. Reasonable appellate minds will argue about the value of an appeal, because an appeal that you lose as Meta could set precedent that really screws you in the future. Winning is great and maybe sets precedent that helps you, but that's where the challenging strategic conversation comes with a client on that appeal, because you want to weigh, if you're just one company and something happened to you one time, you're not worried about the entire marketplace necessarily on an appeal. But when you're Meta and this would affect your entire product, and your product is this large, you have to think through the positives and the negatives, the potential gain or loss that this would affect for all kinds of future types of cases, even other kinds of liability that they might have, which I'm sure their lawyers spend all day thinking about what that liability is, not just for teenagers becoming addicted and having negative mental health consequences, but any other kind of thing, products that are being sold on your Meta Facebook marketplace, or other types of things that the way that you argue and the way that you say you should have been protected, if courts reject that, can be more expensive in the future, as opposed to settling all these cases for $150,000 each, or whatever, metrics they could come up with.
And this is the kind of conversations I presume that Zuckerberg's having with his lawyers as we speak. And my guess is they're going to appeal, regardless.
For now, for sure.
Yeah.
Whether they drop it, whether they tailor it the way I'm describing, who knows? Yeah. But absolutely, for now, that's the first step. They'll certainly file their notice.
Yeah, they want to send a message to Lanier. You can't push us around. So you didn't answer my other. Would you take a case like this?
I think the answer is yes. Okay. I would take a case like this. Every client is different. You have to vet them individually. But if the general premise was that this woman is really harmed, and we believe that we can prove that it was Meta's fault, then yeah.
Well, so just so you know, I've said this on the mic before. I don't know if I said this to you. I think I may have said this to you when we had lunch the other day. I have walked away from Instagram. I think it's been 6 weeks and counting since I last went on Instagram, and it was like 2:30 in the morning on a Saturday, and I realized I'd gone on just to briefly look at some Bulls highlights, which is weird in and of itself. And the next thing you know, it was a half an hour later, and I was scrolling through, and it's what they were getting at, where it's just a ceaseless scroll. They just got you, and I just said, "That's it. I got to end this." And I just put the phone down. I said, "I'm not going back." And again, I always say, listeners, a lot of you send me Instagram links. Feel free to send me those links. They're very helpful. I love them when you do that. But I just click on the link, Jim, just to see what the listener sent, and then I'm out. I'm not sticking around to watch Bulls highlights or Rodney Dangerfield on the Tonight Show or Don Rickles doing stand up from Friars roast in the 70s. I'm done.
This is what the algorithm knows about Ben.
Yes.
By the way, I'm actually the more impressive part of that story is that in 2026 you were able to find Bulls highlights.
No, you can find them
unless they were from the 80s or 90s. I mean, then I could see it.
Okay, Jim, I'm telling you right now, this is the sad state. The Bulls, oh my God, they have a promotions team that's pretty darn good, and they constantly are putting on social media highlights to the Bulls, and it's like it's straight up kind of like totalitarian and marketing. The Bulls got rid of all their good a good chunk of their good players. Io, I love you dearly, at the trading season, and immediately they just transitioned to the new players. Wow, Rob Dillingham. Let's see. I'm like, you gotta be kidding, guys.
Nobody in the listening audience knows who Rob Dillingham is.
I know. There's maybe one. That's okay, guys. All right. So now that we're talking sports, let's stay with sports. This is my absolute favorite topic because it's not really that painful to talk about. And I talked about it a lot at bowling last night. I've been talking about it on the mic. So now you get to join the conversation. And there's a legal end to this.
Mm-hmm.
So, as I pointed out before, Caleb Williams, the great quarterback for the Chicago Bears, picked up this nickname called the Iceman because he came through in the clutch and he was cool under pressure. And he said, I'm going to trademark this and make money off of it. And so he moved to trademark it. He was immediately opposed in that effort by a basketball player from the 70s named George Gervin, who has been the Iceman forever. Okay, in terms of, so if you're a sports fan, there's one Iceman. If you're above the age of like 18 or 20, then you think of Iceman being George Gervin. It's absurd to think that Caleb Williams, as great as he is, can come along and just snatch that from Gervin, and yet Williams was the first to apply for the trademark. Gervin was second to apply, and now they're having this like battle. I don't know if it's going to court, Jim, but it's definitely public relations. And then there's geezers like me and anybody above the age of 65 in the city of Chicago who says, no, the only Iceman is Jerry Butler, who was a great singer and a Cook County Board Commissioner. Look him up, Millennials and Z's. Jerry Butler, the Iceman, great songs. Only the Strong Survive. Check it out, all right? And then one of my listeners, Frank, shout out Frank, said, what about The Iceman Cometh by Eugene O'Neill? Yeah, there's another Iceman. So from a legal standpoint, in your humble opinion, Jim, how can anybody trademark something as generic as the nickname the Iceman? The Iceman just stands for someone who's cool. That's like trademarking cool. How could you trademark cool? And I'm not talking about KOOL cigarettes, which they probably spelled KOOL because they knew they couldn't trademark COOL. Help me out with this one, Jim.
Well, okay, so you've raised two separate questions that are both about trademark law. One being who else might have the right to that trademark, and secondly, how can anybody trademark it at all? Okay, whether you believe me or not, my first reaction, no matter how much I've enjoyed Caleb Williams during the season when they started, there was like announcers would say it or somebody else would say it about him. I kind of thought, I feel like there's already Iceman out there. I know who George Gervin is. It was a little before my time. And by the way, was a Bull.
That's right. That's right.
I'm sure you know that.
Of course I do. Yes.
Of course. You probably saw him in person.
I did see him play. I saw him play against the Bulls and I saw him play for the Bulls.
I mean, I still remember as a kid, they still tried to make him out to be kind of this cool, iconic player. He would talk about finger roll and like there was still a fair amount of marketing surrounding this even into the 90s, long after he was retired.
Yes.
So my first reaction was, that seems like it's taken, but go for it. And as a twist, my understanding is that little shiver move that he's made where he kind of rubs his shoulders, that's also somebody else's thing. It's some soccer players.
Yes.
Move.
Yes. You show that too.
So I don't know what it says about Caleb. Well, yeah, speaking of stealing things in the algorithm, I think when I saw you last, I showed you this The algorithm got me and sold me a phone case that's got Caleb Williams. Like if you rotate the phone in motion,
Oh yes, I
where it
saw
shows
that.
him
It was
throwing
really
that pass
cool.
that he threw to
Yeah,
Rome Odunze.
yeah.
So the algorithm knows my number and takes my money. But so first of all, just because a phrase, you do have to show some distinction about a phrase because a word might be so common that you can't distinguish it at all. But Iceman, whether it's unique enough, is still the subject of you can make that registration. So it's not a question of like the registration office. I think they can reject something if it's too common, or if you're, and remember, it's a trademark. You're not copywriting the word. It's a trademark saying that this is a thing for you that is affiliated with your brand. There's a big difference there because copywriting is original work that you created, whereas a trademark is really more of it's trade. It's for business
Well, all right.
purposes.
Well, let's
So that's
drill down on this. So
yeah,
to this point you're making, George Gervin has been known forever as the Iceman,
yes.
and he does commercials. George Iceman Gervin. If the feds recognize Caleb Williams' ownership as a trademark of the Iceman, can Caleb Williams then block a company from paying George Gervin to do a commercial as the Iceman? Can he take money out of George Gervin's pocketbook by blocking his ability to use that nickname?
So presuming, all right, so let's jump ahead. I'll come back and talk about how he would get there in the first place. But assuming he was granted this trademark and George Gervin's, I was thinking of Jerry Butler now, George Gervin's opposition is what they call it in the trademark world. If that was unsuccessful and the registration office just said, nope, Caleb Williams, for these 20 things that he had in his application, he gets all of them. The actual way that would probably play itself out is that other company trying to sell something with George Gervin affiliated with it, he would file some kind of an injunction to try to get them to stop doing it in the first place. And then how much of it had already gotten out, where the money went. I don't think it would come out of George Gervin's pocket. It probably would come from the company who was using it because they were the ones making money off of it and then selling whatever the product is with Gervin's, signature or likeness or endorsement attached to it. But Caleb Williams, just because he's applied for this, does not mean that he has the right to all of it. So Gervin can, and I think has filed something to oppose this. And what'll happen is over a period of time, most of the time, the parties will just work this out. Maybe he gives them a royalty fee out of the stuff that he sells using it, or royalty fee would be the easiest one because then it's just a percentage of whatever you're making. If they couldn't come to an agreement, there can be a hearing. So they do happen. And it's a question of whether a consumer, an average consumer, I think is the language. It's not reasonable person. It's actually not. In the law, we have all these fictitious characters that we deal with. So like negligence is based upon what a reasonable person wouldn't do under the same or similar circumstances. Like running through a red light with your vehicle and crashing into somebody. So because again, it's about money and it's about selling stuff with a brand attached to it. In trademark law, it's whether like an average consumer who is a lower standard of like ability to distinguish between one thing and the other. If it would create confusion for them, then you can block somebody else from using whatever that likeness is. So the first step would be to get past the opposition in the first place, where there would be evidence. They could put on a bunch of evidence of commercials that George Gervin was in, or the poster, that iconic poster of him sitting in the ice chair in like his ice palace. And then it might come down to, who knows, they might sort of split the thing up and say, well, Williams has asked for these other products where Gervin never expressed this trademark and never used the likeness for the sale of X, Y, and Z, so he can have this one. But for those, we're giving it back to Gervin. But my guess is just because Gervin's further along in life and Williams, the only reason he would have done this is to make as much money as possible off of it. I'm assuming they'll come to some kind of an agreement about it. It's interesting that he never reached out to Gervin in the first place, because it's not like, if it would have taken 2 seconds of Googling this to know, even if he'd never heard of George Gervin, which I also doubt is the case. He's younger than I am. Obviously, he's what, 24 now or 23.
Yeah,
But I
24.
still feel like he must have heard of him somewhere along the way. Or when people started calling him that, somebody had to have said to him, by the way, you know, there's other Icemen. Like,
Yeah.
it's so.
I'm gonna I don't know. This is a whole other question. And you're now going into my bias. I actually am going to push back on you. I bet you didn't know. If I had to put my money on it, I bet he didn't know. And I do the joke all the time on the show. Whenever I reference anybody, person, place, or thing that existed before, let's say, 1990.
I thought you were going to say 2012.
Yeah, 2012 may be the safe bet. And I learned this from Dr. D. Dennis. It always like teased me when we started. He goes, millennials, hang tight, millennials, because he realized his generation had no idea what I was talking about. I'd be talking about George McGovern, who ran for president in 72, or I would talk about Mike Dukakis, who ran for president in 1988. And Dennis would go, I know millennials. They don't know what you're talking about. And so I can guarantee you, well, I can't guarantee it. My bet is that he did not know, nor does he care. There's a great
but when he started meeting with the trademark lawyers, they probably said something to him about it. Maybe that was the first time he learned. But I'm assuming that those lawyers were over the age of 30. But then again, maybe they weren't. I didn't read the application to see who filed it.
Yeah, or maybe they were like, so what? Maybe those lawyers said, so what? See you in court, George Iceman Gervin.
Sure.
And now it's become a talking point on social media, et cetera, and so forth. And Caleb's not looking so good in this because I think the reaction has been, hey, what are you doing? There's only one Iceman. And even Z's and millennials are like, yeah. They're slowly catching up, and so I'm fascinated by it on so many levels. I have to admit, and then there's this point, and I'll leave it at this. Man, capitalism sucks. Just be the Iceman. You're either the Iceman or you're not the Iceman. Why you got to trademark it? Why do you have to make extra money? How much money does Caleb Williams make, Jim?
Well, okay, so here's my bias about this.
Go.
Whatever they do, my hope is that they work out some kind of royalty fee.
Yes.
And then Gervin, who never applied for this before and was waning from the public eye. It's not like he's done any endorsement deals anytime recently. Can make some money and even have a deal where it pays his estate after he dies for 20 years, or who knows? They can work out some kind of deal. But the more money Caleb Williams makes outside of his football contract, the better. Do you know where I'm going with this? Because of the NFL salary cap. At some point soon, he's going to get $65 or $70 million a year.
Yeah.
I would rather he got $57 million a year, and they can bring other players in because I want the Bears to win several Super Bowls.
Now Jim is speaking as a Bears season ticket holder and a Bears fan, and not a lawyer.
Nope,
so you're presuming. Follow me on where you're presuming. You're presuming that Caleb Williams will respond well the way you just said. I'll take less from the Bears because I'm making more off the field. I don't know if he's cut from that. I know Tom Brady wouldn't do that, or I assume Tom Brady would.
I think he did do that. I believe he has. Okay. Patrick Mahomes arguably is taking sub-market money in his deals the last couple of years. He's restructured. Sometimes that first contract is full market value, whatever that. So for Mahomes a few years ago, it would have been about $40 million, I think. And then the restructuring happens halfway through that 5 or 6 year deal.
That
and
is
then
correct.
They cut back on it. And if God willing, the Bears win a Super Bowl in the next 2 years while he's under this contract, and he gets that big one, that he's going to want more of them, right? And don't we all at the end of the day?
Yes.
Isn't that where we'd like this to go? So at some point, and they're going to have to keep re-signing Colston Loveland and Darnell Wright. I hope are 10-year Bears, if not longer. So,
ladies and gentlemen, that is a lawyer, masterful work. I'm the jury. He's the lawyer. I came in with one point of view. I left with another point of view. Great legal work, Jim Coogan.
Well, the
Okay.
cheat code there is I know what would motivate you. I don't necessarily know what every juror is thinking all the
Yeah,
time, but I
that's
try.
true.
It is part of
Yeah.
the mental exercise.
Oh my goodness. Yes. Another Bears Super Bowl would delight me to no end. Another White Sox World Series with my beloved Murakami would delight me to no end.
So now we're getting ahead of ourselves.
Okay, yeah,
That's
now
where we're getting way ahead of
Uh,
ourselves.
So we're going to close down the recording because even though I promised we would talk about the DOJ paying 1.25 million to Michael Flynn, that's not going anywhere. We could discuss that the next time.
I'm sure this racket is self-perpetuating. I mean,
my God.
I don't think that. Do we know whether Trump ever paid himself for his bogus claims of malicious prosecution? Remember, he was going around bragging on his airplane about how it's awfully nice to be in charge of whether I get my own claim. Just sort of musing.
Well, he filed a suit
they've gone
against the
through with
IRS. So I don't know what's going on with that.
Right.
And then there was this case. I think you sent me the article. We were going to talk about that as well, but I just knew these other topics would dominate. The case where, oh my God, he took the settlement money from ABC and I think Meta for his presidential library.
Yep.
And Elizabeth Warren, Senator Warren, was sending a letter. Where's the library? Where's the money?
Both foundations have disappeared.
Yes.
The first one and the second one.
Damn, man, what a goddamn. Come on,
Yeah,
Cranes.
so
Write an editorial.
Meta doesn't want to settle with a young woman who was harmed by their product, but they paid Trump, I can't remember, it was like $15 million. I don't ABC's was 15.
Yeah.
Paid him $15 million for nothing, for a case they could have absolutely defended themselves.
Wow. Heck of a job, Mark Zuckerberg. Absolutely. That is a great way to end it. Yes, they're going to appeal the $6.25 million verdict that the jury awarded the young woman in California. They're fight to the end to that, but they just freely roll over like Fido, the trained dog, and gave Trump all that money. And Lord knows what has happened to that.
For a bribe. It's a bribe. We can just call it a bribe. I mean, that would be a perfect example of capitalism failing. Yeah. That a company would find themselves in a position that it was better to just pay off the chief executive of the government because he yelled at them.
Wow. Because
they knew that they'd get favorable treatment as a consequence.
Yes. And they have been getting favorable treatment. Wow. All right. On that painful irony, we're going to close down the show. Jim, great job. As always, appreciate it. And we'll talk to you real soon. All right.
Happy to see you, Ben. Thanks as always.
All right. I also want to thank producer Chris. And I know that Jim and Donald Trump agree with me when I say, hey, producer Chris, give yourself a raise. Take it out of petty cash. Peace and love, everybody.